Good morning, afternoon, or evening, everyone. Today we will be discussing the landmark Supreme Court case that requires all states to recognize and grant same-sex marriage. In 1996, President Bill Clinton signed the Federal Defense of Marriage Act, allowing states to reserve the rights to ban same-sex marriage. This act also prohibited the federal government from recognizing same-sex marriage. However, in 2013, in a case called United States v. Windsor, the Supreme Court struck down one section of the Defense of Marriage Act that defined marriage as solely between a man and woman. This paved the way for the case we are focusing on today, Obergefell v. Hodges, which reached the Supreme Court the following year. Up until 2014, many states did not allow or did not recognize same-sex marriages. In fact, prior to this case, only 38 states allowed same-sex marriage, with some of these states, including Missouri, Kansas, and Alabama, having restrictions. Jim Obergefell and his spouse John Arthur had been in a long-term relationship for 20 years when John was diagnosed with ALS. Being from Ohio, the two were not allowed to be married in their state. However, after the decision in Windsor v. United States, the two decided to wed. Being from Ohio, a state that banned same-sex marriage, they had to travel to a state where same-sex marriage was legal in order to get married. At this point, John was bedridden, but with support pouring in from the families and friends of the two, they were able to secure a flight with the right medical equipment on the plane. When the plane landed in Maryland, they were married on the tarmac, as John was in such bad health he could not leave the plane. However, when the couple returned to Ohio, the state did not honor their union, and they were told that Jim would not be listed as John's surviving spouse when he died. Although a court issued a temporary enforcement for their marriage recognition due to John's worsening health, the state of Ohio appealed the ruling. Only 3 months and 11 days later, John passed away. Shortly after, this case entered the court systems, and Jim began fighting to make his marriage with John a permanent recognition by the state. 4 different groups with 6 different cases challenged their states at the Supreme Court in Obergefell v. Hodges. The defending states included Ohio, Michigan, Kentucky, and Tennessee. Each case varied, but at the root was the same cause: the need for the legalization of same-sex marriage for same-sex couples. The plaintiff, Obergefell, argued that the state's law violated the equal protection and due process clauses of the 14th Amendment. In a 5-4 decision, the U.S. Supreme Court sided with Obergefell, legalizing same-sex marriage in every state and forcing states to lift bans on same-sex marriage. Justice Anthony Kennedy wrote the majority opinion, expressing that the right to marry is a fundamental right that has always been recognized as a keystone of the social order that secures children and families. He relented that the 14th Amendment had been used to protect marriage laws before, and applied to homosexual couples the same as it did to heterosexual couples. Chief Justice John Roberts delivered the dissent. Though allowing same-sex couples to marry is good policy, the Constitution does not address marriage. Rather, the marriage law should be left to the states. Justice Scalia even went as far in his dissent as to say that siding with Obergefell and allowing an unelected judicial court to write legislative policy for states is unconstitutional. The dissenting opinions agreed that the court was overstepping on state rights. At the time, this case was hotly debated among citizens of the U.S., with only about 58% of Americans in support of gay marriage. Texas Attorney General Ken Paxton called this decision a lawless ruling, while former Governor of Arkansas Mike Huckabee called it an act of unconstitutional judicial tyranny. Many groups, including the National Catholic Register and Christianity Today, argued that same-sex marriages impacted their religious freedoms. Despite the court's decision, 9 counties in Alabama and Texas still do not issue marriage license to same-sex couples, and many states are continuously fighting this decision. Today, about 71% of Americans are in support of gay marriage, according to a poll conducted by Gallup. However, many LGBT Americans fear a rollback of this decision. Thank you for joining in on an episode from Civic Aid today. In future episodes, we will be covering a history of LGBT policy in the United States, as well as other Supreme Court cases in relation to LGBT rights. If you enjoyed this video, please consider liking and subscribing for more.